And now, Alan Jones comments. Thanks to Mercedes-Benz Sydney. New flagship store now open. O'Riordan Street, Alexandria.
It's 7 after 7 on Friday, July the 2nd. A cloudy but fine day. Top of 15. 14 at Liverpool and Richmond. Fine tomorrow and on Sunday. There has been any amount of debate and discussion this week about the disgraced surgeon Jayant Patel, who yesterday was jailed for 7 years for killing 3 patients and maiming a 4th. It is the heaviest sentence of its kind to be meted out in Australia. He'll be eligible for parole in 3.5 years, but this has to survive the appeal process, which has already been flagged by his lawyers. The prosecutor told the court he could find no example of criminal medical negligence as bad as the Patel case. One issue here is what this means for other doctors and the notion of criminal negligence. There is talk that the broader interpretation of Section 288 of the Criminal Code in Queensland could potentially see more doctors charged with manslaughter in the future. Now, this will have to survive the appeal process, and lawyers who know argue that the Patel case will end up in the High Court. Questions also of whether Patel got a fair trial, given the media coverage of the case, and who should decide whether a surgeon's actions meet the standards of gross criminal negligence. Well, those issues are for the courts. But should others be in the dock in relation to the Patel matter? Because this bloke should never have been allowed to practice in the first place. As Hedley Thomas has reported, now Hedley Thomas has written a book on this called Sick to Death. He was the journalist who broke the Patel story. More of that in a minute. But as Hedley Thomas says, this bloke had been permanently barred by US authorities from performing a range of surgery due to, quote, gross or repeated acts of negligence. Now, that was completely overlooked by Queensland authorities until Hedley Thomas did a Google search in 2005 and found an easily accessible website that set out the public findings about this bloke's culpability. In other words, if a half-reasonable scrutiny had been applied, Patel would never have been allowed near Bundaberg Hospital. Yet when he was eventually dismissed, he was flown back to Oregon in the United States, courtesy of a Queensland government-funded business-class airfare. Way back in 1981, according to Hedley Thomas, William Craver, the chief of surgery at the Genesee Hospital in New York, had decided that Patel was not fit to practice for a variety of reasons, primarily because he'd written up a report of a physical examination of a female patient and he'd made it all up. He hadn't even seen the woman. A whole raft of charges against him were proven, like gross negligence, medical incompetence, fraudulently entering items in various patients' medical records, and the Commissioner of Health in New York ruled that Patel had demonstrated, quote, his moral unfitness to practice medicine. Well, he left New York and went to Portland, Oregon, and there he got a job, until an audit in 2000 found, quote, gross or repeated acts of negligence. He was told to go. He did. To Queensland. Under the Beattie government, he was employed by Queensland Health at Bundaberg Hospital in 2003. He's now in jail. I would have thought a few more bureaucrats and perhaps even politicians should be following him. If not, how do you define negligence and the extent to which it ought to be punished?